Hello there. This is An Architect Goes to Law School. Today in civil procedure class, we'll talk about two aspects of civil procedure, statutes of limitations and repose. One important aspect of civil procedure statutes in the United States is the concept of limiting the amount of time in which a person can bring a legal action to remedy an injury. One law of this kind is referred to as a statute of limitations. One example of the statutory language is Alaska's section 09.10.053, which reads, quote, "Unless the action is commenced within 3 years, a person may not bring an action upon a contract or liability, express or implied, or except if the provisions of this section are waived by contract." End quote. Statutorily limiting the time available for bringing a claim is meant to ensure fairness and efficiency in the legal system by setting time limits on when legal actions can be brought, preventing the indefinite threat of legal action. This also prevents the loss of important evidence and witnesses that are necessary for a fair trial. These laws vary from state to state, between state and federal statutes, and between different causes of action. For the purposes of understanding statutes of limitations, causes of action can roughly be grouped into the following categories: breach of written contract, breach of oral contract, personal or bodily injury, and property damage. Relevant to construction law, some states have the same time limitation for bringing suit on both oral and written contracts, while other states and territories have different time frames for these two categories. Because time ranges run from 1 to 10 years among the various states and different causes of action, a best practice for architects seeking to initiate a civil suit is to talk with an attorney about the time permitted for bringing suit on a claim. This time period after which a suit is barred must have a starting point. For statutes of limitations, the statutory time period usually starts with the occurrence of an initiating event. Simply put, a legal claims statute of limitations clock starts when a party actually breaches the contract or causes the personal injury, such as in an automobile collision. This should be contrasted with situations where the discovery rule affects the statute of limitations clock by permitting it to start running only after the damage has been discovered by the injured party. For example, this applies to latent or hidden defects in construction projects, problems that are not necessarily easily discovered by a reasonable inspection of the property. Latent defects can be distinguished from patent or obvious defects, which are those that are easily known. For patent defects, the statute of limitations clock may start when a party should have known about the problem. The court case Sanchez versus Hastings states, quote, "When applied, the discovery rule tolls the statute of limitations until the plaintiff discovers, or through the exercise of reasonable care and diligence should discover, the nature of its injury." End quote. Another limitation on lawsuits are statutes of repose. While a statute of limitations depends on the occurrence of an event that may occur, such as the discovery or expected knowledge of a defect, a statute of repose depends on a fixed event, such as the completion of architectural services or the substantial completion of construction work on a project. While statutes of limitations focus on protecting plaintiffs' rights to seek legal recourse, statutes of repose are designed to provide finality and protect defendants from defending against stale claims. As the court case Gibson versus West Virginia Department of Highways states, quote, "The purpose of a statute of repose is to protect architects and builders from the increased exposure to liability as a result of the demise of the privity of contract defense. Without a statute of repose, a party injured because of a latent design or defect could sue an architect or builder many years after the construction project was completed. This could result in stale claims with a distinct possibility of loss of relevant evidence and witnesses." End quote. As with all laws discussed in all my videos, please verify your jurisdiction's laws or consult with a local attorney versed in such matters before deciding on a course of action regarding legal matters. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up, we'll discuss certificate of merit requirements when someone wants to sue an architect. Thank you for watching An Architect Goes to Law School.